Welcome to Globespan 24/7, our Monday night program, as we bring you issues in the news, the pulse of Guyana. And we look forward for an interesting evening again, as normally do. And we have two outstanding sons of Guyana. We first have Dr. Ramaya, who will be with us for a short period because of the recent events. And after that, we'll have Ambassador Carl Greenidge, who will give us an update on the court matter, the border controversy with Venezuela. We want to thank our audience for being with us. We want to thank Nohar Singh for making this platform available, and of course, Devin Bisu, our technical specialist. So this evening, we want to talk about the trial and impeding decision of the border dispute by the ICJ at the World Court in The Hague. But before we do that, we'll want to talk to Dr. Ramaya. But before we do that again, my co-host, Dr. Rose, welcome.
Thank you, Charles. And you're listening to the Pulse of the People, Globespan Television.
Okay, Dr. Ramaya, we welcome you again tonight. I know you're outstanding. We hardly see you, Mr. Ramaya. Maybe your little angle, yeah, I think it's better there now. Yeah, good.
Okay.
We recently in the news that you were charged with a cyber crime, and I went through the act today to see exactly what you were charged for, but this act is very vague. Can you tell us exactly what happened?
Let me say thank you, Charles, for this opportunity, and Dr. Rose, and to Nohar for Globespan. Until now, it's very puzzling to know that I don't know what I was charged for, to be very honest. And I believe Dr. Rose was here in June when the detectives came with some sort of, I will not say what, some taping on one of my programs that I was accused of calling this pundit name at Crabwood Creek and in a derogatory manner. But the most unfortunate situation here, the matter had no foundation, and I was made to understand that the late commander who left New Amsterdam, he went back and did some filing with his DPP. And now, last Friday, the detectives was here actually to arrest me and to put me on bail. However, after due consideration, I don't know where they got the information from, they asked me to sign a self-bail with no other reason. And if I had refused, well, then I could have been arrested by the detectives who came to my house. One of the things, Charles, that I was amazed of, that here a pundit who was accused by Mona, a singer, of being raped. And I was called at our house by Mr. Harbajan. And I went there and I spoke to her. And on my television program, I only mentioned that justice should be served. However, from since then, I became like a victim more than more itself, because they had a host of people and from the region, and I think a couple of ministers were involved to pressurize me so I can leave the job, because I was bringing out too many things that are going wrong in Region 6, which I pointed out so often. And this has triggered a problem for everyone here who got political ties. This person, he's a regional, he's on the region, the RDC. He's a chairman for a committee. So there are so many ties that this person has that they feel that they can victimize anybody that they want to.
Call his name, it's Pandit Sahadio. Call his name, nothing wrong with that.
Yeah, well, I know him by Pandit Dave. So what happened, I was advised to go to court on Thursday at Springlands Court from the magistrate. But nothing else was given to me, that I was only charged for cyber crimes. I don't know what is a cyber crime.
Right, Dr. Amaya, I went to the act today, and part B of the act, it lists a number of offenses. Did the police tell you which of these offenses you were charged under?
No, no one.
The other thing I heard and the information I received is that the commander who signed off on this charge, he retired recently, and before he retired, he signed it off. Is that correct?
Well, this is what I was told.
Okay.
But
so you don't know?
Nothing at this stage is tangible, and I have not seen anything whatsoever that I was charged for.
So you don't know that. This act was passed by Parliament on July 20th, 2018. From 2018 to now, do you know of anyone who was charged with a cybercrime offense?
No, not to my knowledge.
So nothing went through the court. So you're the first one, and you think it's more vindictiveness than an actual charge?
Yes, that's my strong belief. Yeah.
Okay, Dr. Rose.
Why do you think there's vindictiveness? Who wants to be vindictive against you, Dr. Amaya?
Well, Dr. Rose, there are so many things that I have exposed what is happening in this region. And these are the people who got 10, 15 contracts with different names. These are the people who are going around and doing wrong things, and nobody wants to touch them. And I am not afraid of saying what is wrong in Region 6. Is the worst region in the country, and so many mishap is going on. But one of the things that I am concerned about, how taxpayers' money is being wasted. The government is allocating money for work to be done, and up to today, although I'm not actually working with the government, I send the president some of the things that I found out that people still depending on me to help them with their conditions here. So why are these people being paid a very high salary to clean trenches and drains, and nothing was done? Why is it that the same people, they rotate in all the different committees? From the RDC coming down, there's a lot of corruption. And if they don't like it, there is no way I can able to defend that. But it is wrong for what they are doing. And this individual, I asked the president, bring the contracts out, because nobody has a contract to the tender board. These jobs are given out to people. Like, for example, a $40,000 a month job. 3 and 4 persons working in one home. The fisherman money. All those are corruptions.
Okay, Dr. Amaya, that's a different discussion that we can talk about later on. What we're really interested about, sorry I'm cutting you off, but I want to encourage the people of Berbice. Your court case is coming up on Thursday, you said?
Yes.
And we are asking those in Berbice to go out and support Dr. Amaya. It seems to be a trump-up charge based on what you're just saying. And I think the court, we have a very independent justice system, and I think the court will rule in whatever way the magistrate sees it. If they see a trump-up charge, most likely the magistrate will dismiss the case. But that's something that we'll have to wait and see.
Well, all these things that I mentioned, Charles, I have to tell you, stem from all these accusations that I'm making here are things that I'm pointing out, that they look for a loophole how to bring me down to quit the job and to keep off their backs. And this is the problem here.
And to mention also that if anyone is guilty of an offense under this act, it's almost $3 million in fine plus jail time as well. So it's a very serious act with very serious penalties. So Dr. Amaya, we want to wish you all the best, and we hope that justice will prevail And for those, if it's really because of bring up corruption in the region, they're doing this to you, then the entire Ghana need to wake up to know exactly what's going on. So we wish you all the best, sir.
Any closing remarks, Dr. Moy, what you want to say? Quickly.
Well, Dr. Rose, I mean, a lot of people are calling and in support of the things that they know that many of these names that I've been accused of on Facebook and the lies that they are peddling, there are a set of people who have been paid to do that. I know that I'll get out from this here, but if there is a penalty, as Charles mentioned, then I am prepared right now to be, in all honesty, to serve my time, but not to pay any fine. I'm going to serve that time. Believe what I'm telling you, but not to pay any fine. I've been through this one time with one person, and was a mistake that Camarage made that asked me to pay the money, but not this time, because I know I have not done anything wrong, but I am doing justice for the people of Guyana.
Well, as I said, Dr. Amaya, I think our court system is very independent, and the magistrate and judges do rule independently. And when they listen to the charges and your defense, the magistrate, I'm sure, in his judgment, professional judgment, will make a sound decision. So we wish you all the best, and we again asking those in quarantine to please. Is it at Springland Court, Magistrate Court?
Yes, Springland Court, yes.
Yes. So we ask you to go there to support Dr. Amaya, because he's the one who helps a lot of people in quarantine. Now it's your time to show your support to him. So thank you, Dr. Amaya, and we wish you all the best.
And thank you very much, and tell Mr. Greenidge I say hello.
All right, thank you.
Thanks.
All right, and now we have with us Ambassador Carl Greenidge. As we know, recently the Venezuela made we'll ask Mr. Ambassador to tell us exactly what was the purpose of the meeting. So Ambassador, welcome back to the program tonight. I know you're way down there in the east. It's early morning. We want to thank you for being up to speak with us tonight, to give us an update on what went on at the World Court.
Good morning, gentlemen. And, yes, I'm on the other side of the Atlantic. And the court sat from the 18th of November to the 22nd of November on the issue that is formally entitled Venezuela's preliminary objections concerning the arbitral award of October the 3rd, 1899, Guyana versus Venezuela. And the hearing was to allow the two parties to comment on a letter sent to the court by Dr. Samuel Moncada, who is the agent for Venezuela. That letter of July 22nd, July 7th, 22, sorry, July of this year, the specific date is July the 28th of 2022, which letter contained a complaint by Venezuela, that is a preliminary objection, which said that the Venezuelan government believed that the case lodged by Guyana in relation to the 1899 decision by the arbitration panel was wrong on two fronts. One is that it was procedurally, it was wrong or unacceptable, inadmissible, in fact, is the term they use, and that they were calling upon the court to reflect on the objections they raised in the attachment of Dr. Moncada's letter, attachment to the letter, with a view to pronouncing on the matter. And so on the 18th, Venezuela was given the floor, as it were, at the hearing to make their case Guyana responded on the following day, that is the 19th. And on the Monday, Venezuela was given the opportunity to respond to Guyana's comments. And then on the Tuesday of last week, the 22nd, Guyana was given floor to close its comments and to conclude its presentation. And the court has now therefore retired in order to deliberate on the matter and then to come back to give us their views as to the issues that have been put to them by Venezuela.
Ambassador Greenwich, you've laid it out very clearly, and on behalf of Guyana, I know I'm not the president of Guyana, so I can't speak on behalf of Guyanese people, but when we listen, there are thousands and thousands of Guyanese who logged on to the program to watch the proceedings, and we must salute you, sir. You and your team did a remarkable job on behalf of Guyana, and you all made us proud. Your opening statements, your closing statements, the arguments that Guyana's legal team made were so sound. And in our judgment, of course, as Guyanese, we want the court to rule in Guyana's favor, but we see no reason, based on the presentation of both Venezuela and Guyana, that the court should rule otherwise. But Mr. Ambassador, can you tell us exactly, this is not the main event, so to say. It's not a border controversy per se. It's what Venezuela was objecting to the proceeding. Why were they objecting to the proceeding?
Well, the border controversy, as you call it, was captured for the court by way of a memorial submitted to the court by Guyana, as you recall. And in the first instance, the court was required to determine whether or not it was empowered jurisdictionally, when it had the jurisdiction to entertain the case. That is what happened in the first phase, which ended when the court gave its decision on December 18th, 2020. The court at that time decided that it was in order for it would be in order for it to proceed with the memorial that Guyana had submitted, because the issues raised, namely whether the court was in a position to say yea or nay as regards the validity of the 1899 award, that was in the power of the court, and that the two parties had agreed to the appropriateness of the court deliberating on the matter under a variety of agreements that they had jointly entered into. And those would include, for example, the 1966 Geneva Agreement. I know you don't want me to go over that, but it's important to understand that. You submit a complaint to the court first has to satisfy itself that it is empowered to do it. In order to be empowered to do it, the two parties had to have agreed on some arrangement, whether it is a bilateral arrangement or by the agreement it has with the UN or the court itself, that the court is so empowered. The court decided that it was so empowered, and it announced that it would look at the matter. On July the 7th of this year, the Venezuelans, at the very end of the deadline open to them, they indicated to the court that they had difficulties, or they wanted to lodge a preliminary objection as regards the court's consideration of the memorial that Guyana had submitted. So the court had decided that they could take on the case. The Venezuelans now, at the very end of the deadline, which is available to them for objecting procedurally to the consideration of this matter, submitted an objection, what was called a preliminary objection. And that preliminary objection is what the court agreed it would hear. And that hearing took place between the 18th and the 22nd of this month. And in essence, what the Venezuelans have been contending, that there's a procedural dimension, namely that the signatory to the 1899 award, the 1899 arbitral agreement, 1897 and 1899. 1897 set the rules, 1899 was the decision of the court and its deliberations, as well as the 1966 Geneva Agreement. Those three sets of things were signed by Venezuela and the governments of Venezuela and the government of the United Kingdom. And whilst it is true that the 1966 agreement was also signed by the government of Guyana, as far as they're concerned, the parties to the dispute arising from the 1899 award are the governments of Venezuela and the government of the United Kingdom. And therefore, they're saying to the court, procedurally, the UK has to be an obligatory, or the UK has to be required to participate in this hearing, because it is a matter that involves the United Kingdom. You would have heard for the first time in those hearings, at least most laymen would have heard a set of new or interesting terms, and those are terms that the lawyers have utilized for dealing with these matters. I won't turn to those yet, but let me say the second objection or second observations they were making was that the proceedings, the arrangements, the rules, the agreement governing the resolution of the 1899 award are captured in the Geneva Agreement of 1966. And they therefore argued at great length on these two matters, one of which relates to matters of procedure and the other pertaining to substance, they say, and that substance was the behavior of the United Kingdom during the course of the proceedings of 1899 and the period preceding it, the periods subsequent to it. And these things are all germane or specific to the outcome that the court would have to hand down. And so Guyana responded to this, which is what it was required to do. And as you know, a matter like this is before the court, so one is not in a position to do much more than would have been available to you on the hearings, because they are weighing the different points that were made, and one doesn't want to give the impression of either anticipating the court or knowing what the court is thinking. But basically, for purposes of non-technical discussion, in essence, the court heard from the Venezuelans in the first round the complaint or a set of complaints pertaining to how the British were communicating with each other. That is, British officials were communicating with other British officials and some of the British representatives in the court. And these gave rise to allegations by the Venezuelans about proper and improper behavior, and the term fraud was in fact utilized to describe what was taking place. You would have heard a term like monetary gold used. For me, it is not a term with which I was familiar. And what in essence was being contended here was that the British government was an essential party to the agreement. The deliberations of the court as regards the work of the arbitration panel would have to take into account the behavior of the British. And so the discussion all turned upon the conduct of UK officials as well as members of the panel, or maybe a specific member of the panel. Let me put this more clearly, and that's why one has to be careful about these things. There are rules governing whether or not the court can decide whether fraud or improper behavior was involved in a matter such as arbitration. And what the court heard were a number of allegations, as our own lawyers contended. Yes, some of these things were said. Some of these things that they were saying, that is being alleged to the court, were issues that we had heard before. A number of them arose from the letter that was supposed to be written by one of the junior counsels to the Venezuelan. In fact, he served on the arbitration panel as a junior lawyer, and these allegations were made to the effect that the British had, in effect, some of these things are in fact contradictory. They conspired with the Russian chair of the arbitration panel to give a decision favorable to the British, and thereby denying Venezuela territory that it was obviously entitled, to which it was obviously entitled, and to which it had historical rights. That, in very broad terms, was the contention and the cite allegations. In fact, as all the lawyers have pointed out on our side, the allegations that were made have not been substantiated in any way. They still are broad allegations made by Mr. Mali Prevost, who is the counsel that I made reference to earlier. And whilst they were made by him in 1944, and the publication was made in 49, and by which time he had died, because he required that this is what should happen before it's made public. He should have died. And the others who had other people that were involved in this exercise had by then expired. But the point is that these were general allegations. They were never subject to any critical review, critical allegations, any critical testing. And so we are left in a situation where almost 100 years after the event, someone is resurrecting the allegation of another who is not alive, who made these allegations a month after he received the highest national award of Venezuela, and the court was being asked to treat these allegations as though they are gospel. But the point I want to make at this point, that there are issues, as I said, of procedure, and that's one side, which has to do with the so-called monetary gold dimension and whether or not Britain should be involved. And there were other issues pertaining to some of the specific allegations that were made. And the court has to reflect on all of this. I don't want to go through those now. But the question that then arose at the end, if you are looking at the process regarding the propriety of how an award was made, we were saying that none of the evidence brought to the court, none of the information brought to the court constituted evidence about improper behavior by members of the court itself. None of the allegations that were made constituted proof that the British influenced any specific member of the court, or that the members of the court collectively agreed to any arrangement that was improper. In fact, the lawyers on our side were contending that Venezuela was in error, its lawyers were in error, by suggesting that the very suggestion that they have of communication between different members involved in this exercise constituted corruption or influenced the final decision. That is one side. And the other is that much of the information provided, much of the argumentation being made by the Venezuelans focused upon the behavior or attempt to make moral judgments or make an assessment of the acts of individuals on the British side. The British were not the arbitrators, and therefore that posed us a problem. That was the point that was being made. And secondly, that the rule concerning monetary gold and a state such as Britain involved in an exercise like this would require that Venezuelans prove that the interests of the British are affected. The British recognize that they have an interest and therefore would have said that they should participate. In fact, what is very clear, even from the evidence that the Venezuelans or the documentations that the Venezuelans submitted to the court, it was clear that they hadn't read carefully all the material that they had shared, because amongst that material was correspondence from the British to those with whom they communicated, making it very clear, including with the Venezuelan government, that the British interest was not affected would not be affected by a decision as regards the board. It's not Britain's board. Guyana was independent since 1966. And the question of whether the border is wrong or is not appropriate, given whatever took place in 1899, is a decision for Guyana and Venezuela. And that is why in 1966, it is Guyana and Venezuela that in the end also signed the Geneva Agreement. And there was a process set out in the Geneva Agreement for resolving any difficulties that the two sides might have had. Okay, there's a process there, a long process, which in fact has been triggered and which the Venezuelans seem to feel does not exist. So that in essence is what was before the court, and these are matters in which the court has to pronounce. The court in 1899 spent something like 200 hours taking evidence, examining material, going through documents, and the documents amounted to several thousand pages of evidence, of analysis. It was public also, so any member of the public was in a position to hear or to attend the session. So it wasn't secret, it wasn't hidden, it was the people that were involved were known. And what in essence is being asked is that the court ignore all of that. The court should ignore all of that work that was done. The question then arises, where does that leave the two countries who have signed an agreement which the Venezuelans enforced so strictly for 63 years, and then subsequently questioned, and now wants to be overthrown altogether. All the recommendations should be ignored. I mean, normally, if you have a problem with a decision, there's some element with the decision. It can't be that every single thing that the court handed down as part of that arbitration hearing was somehow flawed. But this is what the Venezuelans are arguing. And you will have noticed that when they were asked what then would be the impact for the two countries, where would their border lie? If you abandon the 1899 agreement, what becomes of the ownership of the mouth of the Orinoco, for example, the estuary? And we were told that the situation would revert to 1966, whatever that means, and that the process set out in the Geneva Agreement, which, as you may recall, began with a mixed commission of 4 years, and then after the mixed commission produces a report, and if the two sides don't agree on the report within 2 months, they have to choose another means of resolving the problem, that the means set out in Article 33 of the United Nations Charter. And then if then they couldn't agree, the Secretary General of the UN would be asked to choose. Now, I'm telling you this because you would realize that all of this we have done already. And it is being proposed that this is the option open to us to resolve this contention that the Venezuelans are now making as regards not so much the adequacy of the agreement of 1899, but as regards the consequence of the court having agreed to consider the case. The Venezuelans are now arguing that there's a dimension, and you would have seen it treated as the question of admissibility, which Mrs. Bihari, a Guyanese lawyer working with the external lawyers, together with the other members of our legal team, explained to the court the implications of some of the things the Venezuelans were proposing, and the very circular and legal cul-de-sac which the Venezuelans were trying to put us in. So, I think to many people, a lot of this sounds very confusing. You've agreed a process, one has gone through the process has ended or is taking us to the ICJ right now, having most recently come out of enhanced mediation, which is part of the means that were listed in the Geneva Agreement and under Article 33 of the UN Charter. And yet, the preliminary objections seek not to resolve any of that, but embroil us even further in a process that is completely and utterly circular.
Yeah, Mr. Ambassador, you said quite a bit, and I know you have a lot more to say. I know Dr. Rose wanted to jump in now, but as you rightly said, they made a lot of allegations, and they had some clips on the screen, but there was no evidentiary document to support those allegations, as you rightly said. Just for the record, where was the 1899 arbitral proceeding were held?
The proceedings were held mostly in Paris. In Paris. This would be because I think the two parties would have agreed that that's a neutral ground. They didn't want it held in London.
And Great Britain had their their team. And what did Venezuela have on that team?
Well, the two sides would have assembled the best legal brains that they could afford, and the 1897 Washington agreement, which set out the rules for the arbitration panel, stated that the two sides would agree on 5 judges. They would agree on 4, and the 4 judges would choose a 5th. Okay. In the case of United States of Venezuela, as it called itself, in the case of Venezuela, Venezuela chose 2 justices, 2 eminent justices, both of whom were American nationals, one of them being the former president of the United States, okay, and the other being a similarly prominent US attorney. The issue here that is important is not so much the nationalities of the judges, because I want to remind you that the ICJ currently has arrangements under which the panel of judges sitting on the ICJ are of varied nationalities. And if, for example, as in the case of both Guyana and Venezuela, none of the judges is a Guyanese and none of them is a Venezuelan, Venezuela and Guyana can choose what is called a judge ad hoc, who can participate in the deliberations of the court, and in a sense, the states can be satisfied that the process that is taking place is fair. Okay. Now, in this case, that is now that we now looked at, and in this case, the Venezuelans have named a judge ad hoc, and the judge ad hoc is not a Venezuelan. I make this point because some of the criticisms Venezuela makes and the devices by which it tries to mobilize Latin support is, look, there's a panel was chosen, and the judges chosen didn't include a Venezuelan, although Venezuela believed that it had good judges. Now, the British had a different view as to the quality of the Venezuelan judges, but the point is, as you would have seen our lawyers argue, there was a logical explanation for the choice of judges. Venezuela had used the United States as a device for forcing the United Kingdom to come to the arbitration. The UK did not want to go to arbitration. The US had interests. I don't want to get there now, but it had interests which they felt needed to be protected by having Britain subject itself to arbitration. And Britain eventually agreed, very reluctantly, to go to arbitration. And Venezuelans felt that if the US judges, if the US participated in the arbitration panel, then the US was likely to be interested in ensuring that any decision unfavorable to the United Kingdom would be supported or enforced by the United States. Am I making sense to you? It's a means of ensuring that the follow-up would be effective, because the US judges would have been, or US judges would have been party to the agreement, and the US wouldn't say, well, we can't be bothered. You all go and talk to the British. So British power was at that time challenged by the US in a sense, and that is what forced the UK to go to the arbitration panel, and in going to the arbitration panel, in agreeing on the composition of the arbitration panel, the US was able to put 2 judges, and the four judges, 2 from Britain the two on behalf of Venezuela who were American chose a fifth who was Russian. And it is on the Russian that the Venezuelans are placing a lot of their criticism. And that is a case that, having looked at the Venezuelan submission, that our own argument, lawyers argue, has yet to be established. I trust that is making sense to you.
Yes, Mr. Greenwich, I know, and I'm going to say this, most of our listeners are not familiar with the ICJ, which means International Court of Justice.
Okay.
Can you explain the structure of the ICJ, the number of justices on the court, and how they're selected?
The membership of the International Court of Justice is meant to be reflective of the structure of the United Nations. So you have 193 or so countries that are members of the UN, nearly 200, and the world is broken down into geographical constituencies, and these constituencies each would be entitled to a judge, and they have to vote. The UK, for example, may find itself, or Guyana may find itself, India may find itself in a situation where in that region, the country itself has a judge. The region is entitled to have one judge, but many members of the region are interested in having their eminent justices elected to the court. Okay, and that is the process. Altogether, you have 15 judges, and they are elected in a process that involves the geographical constituencies, and these are elections that take place in a manner that has the judges being changed every 9 years. If one justice is elected, he can sit for 9 years, and this is a means of ensuring. That the decisions are taken without fear that his own government or a neighbor government seek to have him removed because they don't like a decision that he might have participated in.
And how many justices are in the court?
You have the 15 plus you have two, as in the case in this
two ad hoc, yeah.
You're looking at, you have two judges ad hoc.
Right, yeah. Did Guyana ever had a judge in the court? Or how many judges Guyana ever had in the court?
Guyana has it depends on how you configure.
In the history of the court, how many judges Guyana had?
In the history of the court, Guyana has had, within that wider complex, you had Dr. Mohammed Shahabuddin.
Right.
But the court at the time when Mohammed Shahabuddin was elected, he was dealing primarily with the ICC matters. That's the International Criminal Court.
Yeah, right.
Okay. But in the region is currently represented, for example, by Justice Robinson. Okay, that is a distinguished Jamaican judge of the region.
Right.
And we had the option. We had the option of naming a judge ad hoc, since we didn't have a national sitting on the court.
Okay. Now, in a domestic case, a person can be fined, go to jail, properties can be seized, and so forth. But in the International Court of Justice, you're dealing with countries, and you can't put a country in jail. So if the court renders a decision, how that decision is being enforced?
The court's decisions are decisions that are taken on behalf of the UN as a whole. And in the last analysis, the General Assembly of the United Nations um, receives a report on the deliberations, or not so much the deliberations, as the decisions of the court. And if there are any problems arising from those decisions, they can be looked at by the UN. And in the last analysis, enforcement can be done either by that General Assembly or, depending on what it is, by the Security Council.
This means that impose sanctions on those countries, like what the United States normally do. Okay.
No. The United States may opt to impose sanctions, but those sanctions are not necessarily or not always arising from a decision of the Security Council. It may or may not. I mean, you have to.
Right.
But in this case, if a decision
the UN can impose sanctions on these countries. The sanctions will have to be imposed with a military might or something, and the UN doesn't have that.
Well, you're asking a question, or are you telling me definitively?
I'm asking you the question.
Okay. You will be aware, of course, that there have been problems in Haiti. At this point in time, there's a question being asked: Will the UN mobilize its membership to put a task force? I call it a task force to assist Haiti. This was a question posed by the current Haitian president. And we have had a number of cases in the past where the Security Council has acted to enforce a decision taken by the Assembly as a whole, and more importantly, by the members of the Security Council to enforce a decision of the UN. The UN, in these days, it has no standing army. That is correct. But it can mobilize by asking its membership, those with the capacity to volunteer to provide military equipment and personnel to enforce decisions. It is, of course, a difficult decision to take because you have the members of the Security Council, essentially a 5, and they have veto power. Right. And so you need a unanimous decision if you're going to get a meaningful implementation as regards force, military might, as opposed to, say, economic sanctions or political sanctions. They're easier, but the challenge is the same. Unanimity is difficult.
In the 1899 Accord, Guyana was represented, that time was British Guyana, by the British government, or by the British. And Venezuela was represented by the United States. They had some problems with
Venezuela's request.
Yes. And there are some problems with the Russian judge, but I'm not going to go into those details. And both the United States and
Venezuela,
Britain accepted the decision on behalf of the countries they represented, and Venezuela agreed to it then. But
no,
after
can I just correct you?
Go ahead, jump in.
The Guyanese team has pointed out to the court that the decision of the arbitration panel was accepted by the Venezuelan government and by the Venezuelan Congress shortly after those decisions were taken. Right. And the Venezuelan representative, who happened to be the brother of President Anrat, who was at the time the president of Venezuela, accepted and used very superlative language, quite superlative language to express their appreciation. So the importance of the US ceased after the panel met and the panel took its decision. The criticism, as it were, the US, it wasn't necessary for the US to formally grant its approval. The people that were involved in the exercise were Venezuela and the United Kingdom.
Right.
And as a matter of fact, the Russian judge was a highly decorated judge and the father of the current international arbitration procedures. The suggestion that somehow he had forced others to do things is one, I think, a reading of what happened suggests that Mr. De Martins sought to ensure that as far as possible, decisions were unanimous.
Right.
And that was his crime, because now Venezuela is trying to treat that as though it is improper. But indeed, his approach to arbitration and the need to ensure that the decisions were embraced by all sides was a way to ensure that they were honored.
Right. But after 1966, when Guyana became independent, Venezuela reinforced its claim, saying that they own 2/3 of Guyana's territory and so forth. And this led to the Geneva Agreement. Explain to our listeners what took place at the Geneva Agreement and what were the final decisions reached.
Well, the Venezuelan government in 1962 announced formally during the development sessions of the United Nations that it was not intending to accept the 1899 award. And the explanation given at the time was an explanation that said that they had come upon evidence which would enable them to show the world that the arbitral award was unjust. Again, this is a long and complicated story, but in essence, what Venezuela was doing was attempting to prevent the independence of Guyana. In the court case, you will hear them say that Venezuela had lent its support to Guyana's independence. Well, I don't know what that means. Words can mean almost anything, but let me say that Guyanese now and at the time never regarded an endorsement by Venezuela of Guyana's independence that said, yeah, we agree with Guyana being independent, we will support its independence on the clear understanding that over 70% of the territory will not go to Guyana. That territory will be treated as Venezuelan territory. Okay? And the concerns about what Venezuela was likely to do as a bigger military power, or as a military power, concerned the world. And that led to the establishment of the discussions between the British and the Venezuelans. And at the end of the exercise, at the beginning of 1966, the Geneva Agreement was signed. That Geneva Agreement should be read by all Guyanese because it is only about 4 or 5 pages in length. It is a very simple, I wouldn't say straightforward. As legal documents go, it is quite straightforward, but that is not perhaps for a non-lawyer to be pronouncing on, because lawyers find complications in almost anything. And so the Geneva Agreement was signed by all parties. The basic objective of the Geneva Agreement was to permit the two parties to continue speaking about with a view to resolving the concerns that Venezuela had raised, and which it said it would support later on by providing the evidence. That's what it's called in 62. That evidence, in our view, has never been provided in a manner acceptable to any international court, or by way of processes acceptable to an international court, and therefore that has also contributed to this matter hanging over. But the Geneva Agreement is entitled an agreement arising from Venezuela's allegation. It is an agreement that is intended to facilitate the resolution of one party's unhappiness over some information that they said that they had come upon later. And I was fiddling about just so that I don't misquote the title for you. The title of the Geneva Agreement is as follows, and you would have seen this as one of the things that the lawyers displayed on the board electronically. It is, I'm reading to you the agreement dated 1966, and it's numbered 323 in English and French. And the number of this one is number 8192, Agreement to Resolve the Controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana, signed at Geneva on the 17th of February, 1966. And the important element of this agreement is in that very title. That is, that it is an agreement to resolve the controversy. And it is a controversy because there was actually, if you like, an agreement in place. One party was saying that they had some concerns about some element in it, and therefore it was termed a controversy rather than a dispute. And that is what they signed on 17th of February 1966, the official text in Spanish and English. And it is an agreement to resolve the controversy. It is not an agreement to transfer territory. It is not an agreement to prove that any major misdemeanor was effected. And the agreement does set up, I don't know that I can deal with it all tonight, but in Article 1 of the agreement called for, or Articles 1 to 4.1 called for the establishment of a mixed commission that would stand for 4 years and would examine and would make arrangements to go to Caracas and London to examine documents so that any questions as to the validity of documents, misrepresentation, falsification, these matters could be satisfactorily examined. And that is what Articles 1 to 4.1 say. And the deadline given there was 4 years. And at the end of that exercise, the governments, it was hoped, would have a final report, and that final report would be examined by the governments, each of the governments, and they would be given some time to say whether or not they agree with the report.
Okay. Now, Mr. Greenwich, if the ICJ, and I'm going to repeat, International Court of Justice, ruled in favor of Guyana, which is expected based on the representation there. Guyana presented a very strong representation, including yourself. And Venezuela does not accept, and this is the preliminary objections and so forth, does not accept. Where it goes from there?
Well, Venezuela has entered as a party to these deliberations, these hearings, unlike what occurred in 2018 when Guyana laid the complaint before the court and Venezuela said it would not accept the jurisdiction of the court. Venezuela says no, it isn't accepting the jurisdiction of the court, but it has, in order to fully represent or articulate its complaint, its preliminary objection, it has not only participated in the deliberations, but it has actually named its judge ad hoc. It's named an agent. Venezuela's presentation was complemented by a presentation from Vice President Delcy of Venezuela. So it would be, I think, considered by some as a matter of breach of faith if having fully participated, it were to decide that it doesn't accept the decision of the court. It may not agree with it, but it can't then say, well, it's not going to accept the decision of the court in any way that is more than a political expression. That these hearings were on Venezuela's preliminary objections. If you opt to object to something in a court, and the court looks at the rules, hears your case, and decides that you are wrong, then you have to live with that. As regards the next phase, that is when the court turns to the substantive or the merits, as they call it. That is how the court arrived at, how the arbitration panel arrived at its decision. Did it do anything in its decision, in its decision making that infringed what were then the rules about arbitration? That has to be the subject of an examination post 2022. And I make this point to you. The hearings themselves were complicated enough, and some of the points I try to highlight, not necessarily in any balanced way to you, would reflect the fact that whilst you are talking about an objection as regards procedures, many of those objections actually had to do with the merits of the case. These are the issues that would be taken when you come to go through and establish whether or not things that were done properly, whether the information that was provided was properly provided, or what have you. So they have in a way muddied the water, in my view. I mean, and again, I'm not a lawyer, I'm not speaking authoritatively, and the court will itself give views on these matters if it sees fit. But one of our contentions was that what had turned out to be a complaint about procedures turned to a large extent on allegations about substance, which is what really the court should be considering, not at this stage, but when it takes up the merits.
Okay.
So, as with the court, the Venezuela and any of the members is free to attend the court, participate, and as far as I can make out, at any point they may say that, well, they don't any longer want to participate, or they no longer agree to participate. All of that is possible. As I think even within the context of what you might call municipal law, that can happen. So we wouldn't be presumptuous enough to tell you that Venezuela is going to accept anything at any point in time. What we can say is that they have participated, and that the international community would expect them as honorable members of the international community to bear in mind the implications of the processes in which they have been involved. The court is actually not a single random process of decision making. The agreement of 1966 was preceded by at least 5 agreements between the United Kingdom, Venezuela, and other countries that affected the borders. You had for example, the boundaries of Guyana were not only captured in the 1899 award, but they were subsequently marked out on the ground in an award of 1905 and signed and authorized by representatives of Venezuela and Britain. And the Brazilians took into account those agreed points when they themselves spoke to British government and Venezuela about borders between Venezuela and Brazil. And then in 1928 and 1932, when the tri-junction points were agreed and marked. So there are boundaries reflecting the agreement between Brazil and Venezuela. So
okay.
Just like they were between Guyana, Venezuela, and Brazil.
Okay.
So it becomes a question of whether you will party to a set of agreements. You may be saying it is only the agreement with Guyana that you have a problem with. But what does that mean when 3 or more parties have agreed to boundary points and have agreed, for example, as in Brazil's case, not to pursue claims which they had to the Essequibo?
Okay.
Similarly,
Now,
we have given up claims that we have on to the west, which included the estuary of the Orinoco and
right,
the eastern banks of the Orinoco.
right. Now, I know the two ad hoc judges don't have a vote, but if 15 judges, when they vote, it's 8 out of 15 becomes a verdict for the majority. Am I right?
Yes, it's done by majority.
Okay, thanks.
And
Charles, over to you.
and if any of the judges feel strongly enough, they can lodge dissenting views.
Views. Yeah.
But I want to say to you that the majority associated with the decision about jurisdiction was unusually large. As a layman, I'm saying to you, 12 of those judges were in agreement without any equivocation at all. And of those who disagreed, it wasn't, as a layman now I'm saying, it was not my understanding that the disagreement suggested that they thought the rest of their colleagues were entirely wrong. The issue had more to do with implications. You will see that judges sometimes pronounced on aspects that they think the court might take into account now, but it doesn't affect the decision now. But down the road, it may have implications for the court. So, yes, the decisions are by majority, but those who disagree are in a position to articulate their disagreements in writing. And when you look at those disagreements, you will find often that, well, I don't want to say that they're not radical, but they are often on the finer points of law.
Okay, Charles, over to
Mr.
you.
Ambassador, you mentioned the military might of Venezuela. But I think as we look at the World Cup now, and I think, is it Kaiser News or Stabrook? I'm not sure which one had a nice cartoon of Saudi Arabia defeating Argentina in the opening match.
Yes.
So Venezuela is underestimating Guyana, I believe. And as you rightly said, there is a tenet in the courts, and none of us are attorneys, that he who asserts must prove. Now, Venezuela is making all these allegations. In your layman's opinion, have they proven anything to the court?
Well, the assessment of the Guyana team is that they have not proven any of the allegations that they have made. And on the procedural side, there are problems because we ourselves have drawn to the attention of the court that the submissions that the Venezuelans have made have not, on this particular case, as regards preliminary objections, seem to infringe the deadlines set by the court as to what can be dealt with at this stage. Just to give you an example. So we feel strongly that the case has not been made, that it is not a meritorious case. And if I were to repeat the language used by our main advocates, it would probably sound too harsh. So let me not let me not repeat that. But in essence, what our people have been contending is that the case on the Venezuelan side across the board is without merit.
And what I'm just getting at too, because as I said, he who asserts must prove. If they have not proven their case, is it incumbent on the judges of the ICJ to go and prove what the allegations were, or that's not their responsibility and role?
No, my understanding is that the court will satisfy itself as to whether claims made by either of the parties have been substantiated in any way, and whether they've provided the material to substantiate those claims. It would not normally be for the court to now get up and send out an investigative team to establish whether these things are true or not. So when you come to the court to make allegations, you have to provide the documentation. Let me say to you that a couple of days, not very long before the hearings, the court was sent something like 94 pages of documents something like 94 pages of documents for this sitting itself. And we believe that these are not consistent with the rules of the court as we normally understand them. But, you know, it is not something that we felt could stand on its own anyhow. So the court will see, and you will see from some of the statements we made. I think my own statement made reference to the failure to meet the time requirements.
If I'm not mistaken, Mr. Ambassador, this is not the first time Venezuela is objecting formally, because I think the first objection was that they said that the court do not have jurisdiction to hear the case. Was that the first objection?
Yes, they were denying, they objected to guidance.
And that was denied, that was overruled by the court.
Correct.
Now they're saying that the award was fraudulent because of some kind of shenanigans within the arbitrators of the British panelists and the arbiters. Is that the allegation they're making now?
The allegation is being made, by the way, I would say that the substance of their complaint is that the court should not hear Guyana's memorial. It should not examine or accept or receive Guyana's memorial, although it has said before it will receive the memorial and it authorized our submission of the memorial. They are now arguing that the court, and this is one of the contradictions, that the court should not accept the memorial because Guyana cannot present such a memorial on its own. And of course, what we were asking is, what does this mean? Does it mean that as an independent state, Guyana is not entitled to represent itself as regards its borders? And that Venezuela was saying, well, Venezuela and the United Kingdom, 60 years after Guyana's independence, must meet and decide on Guyana's borders, and presumably Guyana must accept what the two of them agree on. And on top of that, the British are saying they don't have an interest, a material interest in this matter. It is a matter for Guyana and Venezuela. So the other information that was provided, that to which I made reference to, and that's why I was reluctant to elaborate this in any way, actually are not, in my view, and according to our lawyers, are not germane to the contention that Venezuela is making about the admissibility of the case. That the case should, the case that they're making is that the process, the procedures have been breached. The party to the case should be United Kingdom. The United Kingdom should participate, and if the United Kingdom is not participating, then no case should be heard.
Do you think, Mr. Ambassador, this is a delaying tactics by Venezuela? That they will, well, I'm saying that because this is the second objections. When this is over, if the court rule in Guyana's favor, they will throw another curveball into the system to keep prolonging the case. Are you see that happening?
I would not be surprised. We try to anticipate these things as far as is possible, but as with most courts, the courts go out of their way to give parties the opportunity to be honest, good faith participants. And to the extent that they are given the room to argue their case, given time sometimes even beyond what we would regard as reasonable, then the court would feel that at the end of the exercise, the parties, the two parties, must not be able to say, we didn't get a fair crack at the whip. So yes, the procedures in a way sometimes are generous towards those who are obstructive in the process. And Dr. Rose is going to be in a better position to defend and explain such a stance by the courts. But that, I think, is an assessment that you have to try and ensure that each party feels that they got a chance to explain themselves, to present their evidence, to question the interpretation of the rules by the other side. And that is where...
Mr. Ambassador, I mean, from a layman's point of view, and I watched most of the proceedings, it is really laughable what Venezuela is arguing. So my point is, if Venezuela loses this round again, which is likely they will, and they come with another objection, will the court just dismiss it, or they have to go through that process all over again? When will the court says enough is enough?
The procedures for the type of delaying tactic as regards the examination of the memorial, I think will have, depends on what the court says when it reports or when it hands down the judgment, but the scope for delay using that procedure will largely be exhausted. Now, I'm a legal expert on these matters, so I'm giving you my understanding of what I've been told by the lawyers. What I can say to you is that in the case of Kenya versus Somalia, you had instances where the one party even withdrew and then fired its lawyers in a manner that appeared to leave the court with little scope, but to agree to extend the time available for the preparation of the case. Now, this was part of a process that had been going on a good while, and the court in the end brought that process to an end.
How long was that process? How long did it go on? The Kenya-Somalia case? The
Kenya-Somalia case, I think altogether took about 4 years. I published a piece on it last year.
About 4 years. So we are what? We're 2 years now into this?
No, that one they fit.
Our Guyana Venezuela is about what?
Well, the case was submitted. The complaint was submitted in the middle of 2018.
2018. So we're like 4 years already, almost.
Yes, but you of course have had complications in terms of COVID and
okay.
Other stuff. But
Mr. Ambassador, I want to go back. I know we're running out of time, and this is not part of the discussion, but if I can recall in my history classes that before British Guyana became Demerara, Berbice, and Essequibo, I believe Essequibo, and you can correct me if I'm wrong, was part of a Dutch colony. And then with the Treaty of Versailles, I believe that the Dutch exchanged Essequibo for another territory that the British give to the Dutch, and the British give Essequibo to Guyana. Is that your recollection of our borders?
No, you are conflating or putting together several different events. Let us forget the story with New York and Suriname. That's a different thing completely.
No, Berbice was a Dutch colony.
No. What was Essequibo? Because Essequibo wasn't Dutch as well?
Can I finish?
Okay, go ahead.
So we forget the story. In fact, Suriname started off as British territory. But Guyana, as we know it, the 3 colonies of Guyana as we know them now were part of the Dutch West India Company grant. So the territories of what was called then the United Provinces. These are the coastal states of the Netherlands.
Yeah.
The major late 16th to 18th century power in Europe, sea power, alongside Spain in particular. This is what happened. The Pope, who was of if I remember correctly, Spanish and Portuguese nationality by birth, awarded the so-called New World to Spain and Portugal. Coincidence? Anyway, it happened.
Yeah, yeah, okay.
And in looking at that decision, the United Provinces, the so-called territory of the Netherlands, Belgium, those coastal states, never accepted that division of the world. And so during the course of the 16th century in particular, the Dutch established colonies all over the place, in the West and in the East. So you had a Dutch East India Company. At the same time, the Dutch were fighting Spain for the independence of the Dutch United Provinces. And when the Dutch War of Independence, which lasted some 80 years, when it concluded in 1648, it was after the Spaniards, the Dutch, the Spanish crown had agreed to give the Dutch their independence. And because the Dutch felt so strongly about the importance of its colonies, not for humanitarian purposes, but for the survival of such a small state, the availability of labor, slave labor, the availability of raw materials and so forth, the Dutch held out in their fight, which could have ended since 1619, until such time as the Spaniards agreed not only to give the Dutch independence, but to ensure that the territories that they held in the West Indies were also part of the territory that the United Provinces could have. So, and in the case of Guyana, the three territories, notwithstanding what the notwithstanding what the Venezuelans try to say now, Essequibo, Berbice, and Demerara were part of that arrangement, in which the Dutch were formally given under the Treaty of Munster, actually.
Yeah.
The Treaty of Munster in 1648 were given these three territories. Now, all of them were Dutch, and the language of the three territories is very interesting to follow. If you look at the Creole of Berbice, which died out in around 2012 or something like that. The last speaker of it died in the first decade of this new millennium. This was Creole with a difference. The Berbice Creole had more Dutch in it than it's probably common even in the region, but more importantly, it had an unusually large quantum of African and specifically a territory of Nigeria in it. That's one side. So the Creole of Berbice and Berbice River was rather different from the Creole of the Essequibo. The Creole of the Essequibo was a strong Creole that died off a little earlier than the first decade of the 21st century, but it reflected also the balance of power in Guyana as regards the Dutch. So it wasn't so much a Creole that, let us say, was dominated by Amsterdam, which of course is the capital of the Netherlands, but it was of the Amsterdam's competitor, and you see it in the literature on linguistics, including the work of Ian Robertson, who you might know. Robertson was a University of Guyana lecturer for many years. He is now a lecturer, probably retired, at the University of the West Indies, very distinguished in this area. And if you have a look also at the literature produced by the Dutch universities, the University of Leiden in particular, which is looking at the language and the culture of the Dutch. They suddenly remembered that Essequibo was so important to them. Indeed, at the time of 1648, in the century following 1648, the most rapidly expanding colonies were in the Dutch mix was probably, well, undoubtedly Essequibo initially. So you've had, as is not unusual, differing fates of different countries over the centuries and over time. But the relationship between Guyana and the Netherlands is well documented. The culture, if you go recently, let me say in 2012, the Dutch TV station KRO did a program. I might have mentioned this to you before, and the KRO did a program on the governor of the Essequibo, the combined Essequibo, Demerara, what was called the two rivers. You had the three colonies, but Demerara was governed from Essequibo. And the governor of that combined colony was a Dr. Trotz. You might know the name Trotz because it exists up to now. There's continuity in the occupation of these areas, continuity in terms of place names, okay, continuity in terms of the activities, continuity in terms of language and culture, and the work of KRO, which was very interesting. KRO, in their investigation, was able to identify the descendants of Dr. Trotz, who included, which descendants also include a Dr. Trotz, still resident, Trotz and his relatives, still resident in Guyana, including in Essequibo. One of those is an agriculturalist who I had the privilege of meeting not so long ago. And you would, of course, probably know Dr. Neville Trotz, who was the scientific advisor to the Commonwealth, who worked at UG, taught at UG for many years, and who grew up in part in Essequibo and I believe in Betafo at least.
Mr. Ambassador, I know you're an outstanding economist and a minister. I never knew you were a distinguished historian as well.
No, I wouldn't label myself in that manner, but I take an interest.
Thank you for the correction and that explanation. And I hope that you can speak to our attorneys at the court so they can incorporate, hopefully, some of those historical facts into our case against Venezuela.
The memorial that we submitted to the court includes a far greater range of facts about continuity than I could possibly spend.
Well, Mr. Ambassador, time has really run out on us. We want to thank you. You're all the way across the Atlantic. It's what, 3 o'clock in the morning there, 3:30 in the morning. You're still up with us. Is there anything in closing before we close off tonight?
No, I just want to say that Guyanese have to be patient in looking at this process. At this point in time, the court has its procedures to go through. It's in our interest that it does those satisfactorily, that we understand what is going on. It's one phase. When that one phase is completed, we will turn to the more substantive phase. It isn't going to be in the middle of next year or early next year, the court saying, oh, Guyana is right and therefore its borders stand. That process, undoubtedly, Venezuela will persist in wanting to take the thing through the court. And we have to ensure that process is as expeditious as possible, is as complete as possible, so that the world does not have to go through these exercises in another 123 years or not 100 years, as our lawyers were pointing out. It has to be done properly, so there's no excuse, no window for our neighbors to wake up and suddenly decide that they want our territory and that there's some justification for that.
Thank you, Ambassador. And I hope Venezuela also look through World Cup and knowing that little Guyana can defeat them as Saudi Arabia did to Argentina.
Oh, goodness.
Dr. Rose, anything in closing?
Okay.
I want to say that Hugo Grutas is considered the father of international law. And in one of his writings, he says, and I'm quoting him here, that that any court ruling should bind the aggrieved parties. So if the court rules, then both parties have to agree with the ruling. But the parties don't in this day and age. So that's where we have more and more conflicts and more processes going through. But having said that, I want to continue to say that I think the retirement age in Guyana should be increased from 55 to 62 years old. And salaries for police, teachers, nurses, public servants should be at least $150,000 because of the high cost of living. And internet, we're still having a lot of problems with our internet. You call in Guyana on the internet, the service goes off. Blackouts. I was told blackouts started since way back in the 70s. So we're looking at almost 50 years of blackouts, and that has not been solved. Water shortages is the same thing. And as Joey Jagan puts it, if these things are still happening, how can we speak of a developing country or a developed country? But we just have to wait and see what will happen. That's my.
Thank you, Dr. Rose. Thank you, Ambassador Greenidge, and to our audience. Thank you so much for being with us. To Nohar Singh and to Devin Pisu. Until next week, good night. God bless our great.